Good evening, ladies and gentlemen, boys and girls. If you are a criminal justice junkie, you are in the right place. Welcome to HCCLA's Reasonable Doubt. The Harris County Criminal Lawyers Association brings it to you every week right here on Houston Media Source. I'm your host, Jimmy Ardwan, along with my co-host, Julio Vela. We're back.
We're back.
We had an unscheduled vacation last week.
We're back. Anytime that we're hanging with Raul Rodriguez and Jason Luong, it's a good night.
Hey, we're back in the saddle. We got two great candidates, both from the Democratic Party. One running for felony court. Jason, of course, running for the 185th. Raul running for County Court at Law 13.
Correct.
Criminal Court at Law, I should say. We didn't even on the civil side. I guess it doesn't even go up that high. It only goes to what, a 4. So
right.
We're not even going to get that high. But they'll be with us for the next hour. We'll be talking a bunch of issues down at the courthouse. Hey, guess what? We got some proposed new courthouse space. Woohoo! What is that all about?
I'm getting my concealed carry.
You are?
I thought because it's gonna be a place where you might need it.
Where you might need it. You haven't gotten it before?
No, I should no. But you know what? Nah, one less, man. One less.
I'm sure now is really a good time to be getting your concealed carry with all the gun debate.
One less. One less.
But we will open up the phone lines probably about halfway through the show. 713-807-1794 is the number. I'll also have Twitter up at HCCLA_TV, so you can hit us up there for any questions and comments you might have for Raul and Jason. But guys, let's. It's been an interesting week here. A lot of stuff going on with the gun control debate. We've had, like I said, we've got new courthouse stuff going on. We've learned some about the courthouse badge program. Just a lot of interesting things going on. Some stuff out on social media in the blogosphere going on. We don't have to get into it all, but I guess what I want to start with is hear from each of y'all, give you guys the chance to kind of introduce yourself to our audience and tell them about your run. So Raul, why don't we start with you? And I'm doing that because you've been on this show before.
Yes, I have.
So I'm gonna start with the newbie here and let him go first.
Well, hey, Jimmy, JV, thank you very much for the opportunity to be here. It's great. My name is Raul Rodriguez. I'm running for Harris County Criminal Court at Law number 13. It's a misdemeanor bench, handles Class A and Class B misdemeanors, as you guys are very well aware. Yeah, I've been practicing criminal law for 26 years, and in that time I've done almost every type of criminal case series, from a speeding ticket to capital murder, and most every type of criminal cases in between. And in my 26 years of practice, in Harris County, I've handled over 11,000 criminal cases.
Wow.
So how does one practice for 26 years, but you only 38 years old? No, so I've known Raul since I was a puppy lawyer, so I've been practicing now for 9 years. He's one of the first individuals that stood out. I've seen him try cases. I've seen him fight in court. And it's a pleasure to see you running for a bench.
Well, thank you, JV. I appreciate that very much. It's one of my passions. When I graduated from law school and became a lawyer, that's what I wanted to do, is criminal defense. And from day one, that's what I wanted to do. And I remember my very first trial. It was in Court 4 back then. It was with Judge Anderson. And it was exciting. I must have been about 6 months out of law school and practicing, and I got a not guilty on a misdemeanor theft case. And it was so excited, and my client was ecstatic. And ever since then, I got that bug. This is what I want to do. This is what practicing law, criminal defense is making sure the individual's rights are protected, and I held the state to their burden.
I remember the first not guilty I got. First I was like, wait, what did they say? Not guilty. And then I looked to the clients, and I remember telling them, they looked at me asking, what do I do now? And looking back at them and saying, you're free.
Go, get out of here.
Go.
Yeah.
And it was that moment that I realized I'm supposed to be not only any type of lawyer, but a criminal defense lawyer. And you can see that in the courthouse. for the individuals who know that that is what their calling is, to be a criminal lawyer, to defend the individuals. And I've seen it. And I've seen it in you too.
Well, thank you.
And I've also seen it in my good friend Jason Luong.
What do we need to know about you? Because the last time you were on the show, you weren't running as a candidate, so.
I was not. My name is Jason Luong. I'm running to be the judge of the 185th District Court, which is a felony court. I actually was a prosecutor assigned to this court when I was at the Harris County District Attorney's Office. I think what's interesting about this race and about my candidacy is that you probably know this because we're in the courthouse all the time, but Vietnamese is actually the third most spoken language in Houston. And it's one of the largest populations in Houston, but there's never been a single elected Vietnamese judge, either civil court or criminal court. And so if I were elected, we would have the first Vietnamese American judge elected in Harris County history. And I say that's important because we've seen this with our clients, whether we're talking to victims or our own clients, is that people don't want to be involved in a criminal justice system where they don't see anyone that looks like them or they feel they can relate to. And when I was at the district attorney's office, I was one of a handful of Asian prosecutors. And you feel that because they don't trust the system. They don't know what it's about. So in this sense, it's an important election because we can put some qualified minorities as well as other qualified candidates who will reflect the diversity that is Houston. So I'm proud to run. I'm proud to run with Raul, and thank you for having us on your show.
Absolutely. You know, the early voting has started. Obviously, the primary is next week, and
2 weeks, March 6th.
Is it 2 weeks?
Well, not 2 weeks, but a week and a half. Next week is still early voting.
Oh, that's right. Gosh, I can't even keep my calendar straight anymore. But
well,
so
they've also moved a lot of the locations, like the old location at the Harris County Administrative Building. You could vote there.
Right.
But it's actually now at the where the law library is.
I don't even know where the law library is.
I know. Well, that's the.
I barely knew where it was in law school.
That's one of the problems you have is that voting locations have changed because of Harvey, and so people really need to take a look at where their early voting is happening and when their ultimate poll location will be.
So the early voting has started, and some of the stuff that I've seen has said, both on the Republican and the Democratic side, the numbers are just off the charts in terms of people coming out. I saw one stat that said the Democrat stats are up like 300% in Harris County.
On the first day, first day of early voting, the number of people that voted in the primary Democrat was up 300% from 2014. That's incredible. That is really good. That just goes to show you that people now are involved and they're sending a message. I think they're sending a message out.
And that's kind of I guess where I kind of want to leap off with you guys. I mean, a little bit in terms of why you got into this, because Raul, you've been doing this for a long time. You've had a successful practice, like you said, for 26 years. And you want to give it up and go be on the bench. And Jason, you've progressed now. You have a very successful private practice, and you want to give it up and be on the bench. And I mean, I see a lot of people now that we've had a lot more people running for office, I feel like, this year than in any other year we've seen. I mean, we're seeing people getting primaried. We're not just seeing primary contests on the Democrat side where we have what I would say a record number of candidates coming out, but we have primary challenges on the Republican side as well. That it's not just that the Democrats believe that they want to try and change the system. We're seeing from within the Republican Party that the Republicans kind of want to change things too and get a fresh start, so to speak. What's you guys' perspective on that?
On the misdemeanor side, in county criminal court at law, there are 16 of them, 16 county criminal courts of law. And 15 of those are currently held by Republicans, Republican judges. And it's been that way since 1994, over 20 years. And then finally, for the first time in 2016, we got a Democratic judge, which is Judge Jordan. So he was able to win his election. And because of the fact that we've had Republican judges for the past 20 years, over 20 years, it's become kind of stagnant. The misdemeanor courts have become kind of stagnant. The judges have become kind of complacent. And it's time for a change.
Each of you have been involved in the justice system and in politics for a number of years now. This isn't the first time that you've gone around these election cycles. Do you find that this year is different than others? Is there something, a spark out there, or do you think that it's, what's different now than maybe in previous years?
Well, this year you've had a lot of judges retire. So a lot of these seats are open seats because I think there's a belief that the tide is turning, and so a lot of judges are retiring rather than being voted out of office. That's not the case for every single judge, but there's a lot of judges retiring. But also, this is the last year that in November you'll have straight ticket voting. And in Harris County, straight ticket voting has been very important in building the Democratic base. And so that's why I think that a lot of folks are jumping in, and some of them aren't necessarily qualified, some are qualified, but you have a lot more candidates because they know that after this year it could be more difficult to win riding the party's coattails. So, but also I think there's a wave of belief that the way our government is being run, that people want to have an effect, a change in the government, and they want to become public servants. So you have a lot of combination of factors working towards getting that. For myself, I know it's because, you know, you're right about having a successful career, but there's something to be said. My family's have all been civil servants. My mother worked for the Houston Police Department for over 25 years. My dad worked as an accountant for the city of Houston for 25 years as well. My sister's a doctor at UT Physicians. So public service is a part of that for me, and a lot of people now see this is the time to effectuate that, their personal desire to go into public service.
Do you find that surprising, the Vietnamese population is so underrepresented in our judiciary?
Not really. I mean that because there's a lag time in which, you know, people came from Vietnam in 1975 like myself, and so I was a baby. So this is like the first generation of people who are qualified lawyers to go. My dad came here as a lawyer, but of course the language barrier, you couldn't become a practicing lawyer off the bat. People in my family who are doctors could because it's kind of a universal language of medicine. So this is the first generation in which we have qualified candidates running to be judges from the Asian community, Vietnamese community. So it's not surprising, and I think it's going to be a big boon for the public service in general to have more Asian candidates. You know, we elected our first Vietnamese state rep, Hubert Vo. We had Richard Nguyen, who was on the Houston City Council, so there's growing numbers of representation for those groups.
Can you imagine if you're the first Vietnamese elected judge?
Well, my wife, who is a Marine, she's not active service, she's already told me if I don't win, I better not come home. Because there's a lot riding for our entire family. My parents are already telling their friends I'm going to be a judge, but we need everyone's vote.
No participation trophy for you.
That's right. That's right.
It's either win or go home.
I think we're all married, so we know know what our wives want from us.
Speaking of demographics, you know, the Latino community in Harris County, there's about over 40%.
Right.
But when you look at the judiciary, especially the county criminal court, how many judges are Latino?
We got Judge Vanessa Velasquez.
I'm not talking about, I'm talking about county criminal court. In county criminal court,
Linda Garcia for a moment.
And there's one that I can think of, Natalie Fleming.
Fleming.
She's Cuban.
That's it?
That's it.
And what are there, 10,000 misdemeanor cases a year?
Yes.
15,000?
And how many of those county criminal court judges are minority? There's only 3.
You got
Natalie Fleming. There's
Jordan.
Judge Fields, and Judge Jordan. And that's it. So that's one of the reasons also, like Jason, that I'm running. Because there's not enough representation in the Latino community or the judiciary. And Vanessa Velasquez, she's in district court, and she's the only one.
Is she running? Is she up for the bench?
She's up, and I believe she's running for re-election again.
What do you guys think? Because both of y'all are competent, qualified criminal practitioners running for criminal benches. What are your thoughts about some of these interlopers who are coming in who have either never handled a criminal case, never appeared in a criminal case, or maybe they kind of dabble in criminal law, and now they feel like they should be able to run for a criminal bench? I mean, obviously there's no bar to entry. We don't say you have to have this in order to get it, but I mean, do you think that the party should exercise some control in the candidates, some more control in the candidates they put forward?
Yeah, I think they should. They should exercise a little bit more control. You can't prohibit someone from running if they want to run.
Right.
But of course, that's the power of the vote. If you have candidates, and if people do the research and they look at who the candidates are, and they weigh their experience, hopefully that will overcome candidates just wanted to run just to be judge. In my particular case, I'm the only candidate. I'm also an associate judge with the City of Houston, and I've been associate judge with the City of Houston since 2005, 12 years of judicial experience. And in the Harris County Criminal Courts at Law, I'm the only candidate that has judicial experience. I'm the only Democratic candidate running for judge in Harris County Criminal Courts at Law that has judicial experience.
As each of you running for a bench over a criminal court, what do you think are the biggest challenges that face a criminal judge or a judge presiding over a criminal court, A, in a misdemeanor court, and or B, in a felony court?
I think the biggest challenge we're going to have in the short term is logistics, because we've got a conflux of too many people in our jails. I think the statistic is somewhere at 75% of people in the Harris County Jail are waiting for their case to be resolved. They're not found guilty of a crime or being punished. But we've now have everyone splitting and sharing courtrooms, which means, I have to tell clients now that, we could fight your case, or you could do like the DWI PTI program, but you'll probably be done with that program before you go to trial, even if you had a great triable case. So the logistics of getting cases resolved so that you can clear your docket, so that the serious crimes need to be tried, because you've got not simply for the defendant's rights, but you've got witnesses or victims. You can't wait 3 or 4 years to go have that case tried because memories fade, and that's a big deal about the Speedy Trial Act and your right to go to trial quickly. But the logistics, safety issues, the report that came out about the Family Law Center not having sprinkler systems,
that's a little bit of a problem.
The logistics are going to be the big part of justice for the next, decade, until we build better and more efficient courthouses.
We're not building better. We're just going to gut the one we have, and they're going to...
We're being optimistic.
I think you're way too optimistic.
What about as a judicial candidate coming in to sit over a misdemeanor bench? What do you think is your is a primary concern or a biggest issue that a judge would be facing coming in?
Well, I think the biggest issue that a judge would be facing is bail reform. It's been like that for years, how individuals who get arrested for small misdemeanor offenses, and I'm talking about things like criminal trespass, small little amounts of marijuana, where they would be incarcerated, and if they would have priors, the magistrates would set the bonds at $1,000, $2,000, $5,000, and they couldn't afford to get out because they couldn't afford to pay bond. And a lot of these individuals were either working class people or not working and low income. And so they sit in jail waiting for their cases to be heard or disposed of. And it's just it's a burden on the jail system. And that's the reason that in 2016 there was a federal lawsuit that was filed against Harris County, against the Harris County Criminal Courts at Law judges, because there was a female that was incarcerated for trespass that stayed there for like 6 days, and she couldn't get out because she couldn't afford the bond. And she lost her job, almost lost her family, just because she couldn't get out. So why can't a judge release that person on a pretrial bond, on a personal bond? That's a very big issue.
Do you feel in the due process concerns that are there in the misdemeanor courts, as a presiding judge in a felony court, there are some individuals who are facing the same due process violations?
Of course, you've got a lot of theft thirds. I represented a client on a court-appointed case where she was stealing basically body soap. It was like probably $50. But because she had stolen before, it was a state jail felony. And she sat in custody for like 30 days. So those issues spill over because of the enhancement effects of from misdemeanor cases. But also you've got people, on a serious crime, even a drug case, you may have a $10,000 bond. You know, I still see outrageous bonds in felony cases all the time. Then the worst problem is that now we've got people waiting in custody. In respect to bond reform, the judge won't set their bond until they get evaluated by pretrial services, like for non-arrest bond. So you can't make a non-arrest bond, and so he has to go in and be evaluated when, shoot, my client would just rather make the $1,000 bond. You know, he doesn't have to worry about it. But you do see a lot of those spillover effects with felony cases, and you still have, I know we've all represented people where, of course, they'll take the 1244A time served because they want to get out and be with their family or get their job, even though they may have just been at the wrong place. I mean, you hear that a lot. Been at the wrong place at the wrong time, or they've got a valid defense.
What's your position on pretrial bonds for felonies?
Well, you know, I agree with the growing sentiment that for nonviolent offenses, they've got to be evaluated. But for nonviolent offenses, people should be, the presumption should be towards release and pretrial supervision. You know, we've got to be concerned about people we're scared about versus people we're mad at. You know, people who commit crimes because they're hooked on drugs or using drugs versus people who are really violent offenders. And the pretrial bond system, the way we've tried to, the judges and the reform that's been enacted, is to screen out violent crimes, not simply people who are repeat offenders on nonviolent offenses. So,
you know, Judge Stanley says jail is for people we're mad at. You know, and as a judge presiding over a misdemeanor bench, what are your thoughts on bail in a court, in a misdemeanor court?
Well, the purpose of bail is the promise to appear in court. That's the reason that there's a bail. So whenever someone is arrested and gets a bond and makes a bond, whether you pay it or a pretrial bond, that person is promising to appear back in court on his court date. That's the purpose of bail. It's not a purpose to punish somebody. So someone that's incarcerated and can't afford to bond out is being punished. And is being punished by the fact that he can't be released, he or she can't be released. So if you give that person a personal bond, if he qualifies, if that person qualifies, why shouldn't that person be released, especially on nonviolent cases? Small little things like driving while license invalid, criminal trespass, shoplifting. You know, why can't those individuals be released on a pretrial bond so that they can't lose their jobs or be away from their families? And most of the individuals in misdemeanor court are working class individuals. You know, a lot of them live paycheck to paycheck. And so they can't afford to lose their jobs or be away from the jobs for a long period of time.
Well, but doesn't it really get back to a logistics issue, as Jason was saying? Because, I mean, how many magistrates do we have? 5, 6?
I think 6.
I think it's 6, yes.
Okay. And how many, what was it? What was the stat? 30, how many misdemeanors were filed in Harris County?
I thought it was like 10,000.
It's more than that. It's way more than that.
It's a lot.
Well, but the fact is, I mean, logistically, if you're going to have hearings for all 10,000 of those people, 6 magistrates ain't enough.
Agreed.
You can't do it. And I mean, if you want to have individualized bail hearings for people, because that's really what it comes down to. I mean, when you read the opinion from not just the Judge Rosenthal's injunction order, but also from the Fifth Circuit opinion, I mean, there are things that it's not just about appearing for court. It's safety of the community, you know, reasonably assure their appearance in court. But there's all sorts of other factors, you know, risk of flight, all this stuff. But the only way you can make a true analysis of that is to have a hearing on it and bring witnesses and present evidence. Well, guess what? That takes time. And logistically, how do you do that in the Harris County system with just the sheer numbers that we have?
How are you going to do it, Jason?
I mean, would you guys be opposed to, let's say, the county court judges themselves having the bond hearings?
well, when the case gets before the actual district court judge, you're like the last line of defense or the second tier to review. In the same way that probable cause, you know, if it hasn't been done by the magistrate, then it can be reviewed by the district judge. I think that's the same thing. It's a little bit different on the felony side because you have a lot more of these, the misdemeanors are so numerous. When you have homeless people arrested for criminal trespass for the 20th time in the same location. But I do believe that it's going to require work from the defense lawyers. That's just the reality of it.
Yeah.
And even with court-appointed lawyers, we've got to make sure that if there's a bond issue, you know, are they being compensated so that they'll work on that bond issue? Because, you know, I did economics at Rice, so I look at the numbers and think, okay, if we're paying a court-appointed lawyer $100, you know, to do the bond issue, but it saves us keeping that guy in custody for 30 days,
right.
because you miss that bond window, you're waiting 30 more days.
Right.
You know, how much are the county paying per day to keep that person? I mean, so
true, but I guess my point is, you know, and how do you functionally? You're paying a court-appointed lawyer to do most of this stuff, right?
well, for these cases where that's going to really matter, it's going to be.
Well, I mean,
they're going to have a court-appointed lawyer.
Yeah, because I mean, look, somebody gets arrested at 2 in the morning. It's very unlikely that they're going to be able to retain an attorney for a bond hearing at 4 a.m.
But
you know
what's going on now is when those individuals are arrested, they go before the magistrate, and now the public defender's office is having attorneys there at the magistrate's hearing to represent those individuals that are incarcerated when a bond issue comes up.
Right. I guess the rub is, and I think you can draw a distinction in between the different types of cases. A driving while license invalid case. A nonviolent offense, you've now just really criminalized an administrative issue, okay? Nobody got punched, nobody got hit, nobody's really suffering. So when you're looking at a bail issue for somebody that is driving while license invalid, they're probably not a flight risk. They don't have a driver's license. Where the hell are they going to go? It's not like they're going to get out of the country without any form of identification, okay? They're not a danger to the community other than the sense that they're driving without a license, okay? Great, there's a lot of people that do that. There's a lot of people who do stuff without a license. I wouldn't consider that a huge danger. So now you're really trying to assess, are they going to go to court? That's what it comes down to, right? But you come to the spectrum of, let's say, an assault family violence or a felony assault case, or even you get a little further up the chain. I mean, you're now having to assess as a judge all those factors. And that takes evidence. That takes a lawyer going out, finding witnesses, potentially finding documents to show a judge, look, here's why this person's not a risk of flight. Here's why this person's not a danger to the community. Here's a witness who will tell you. He's known this person for a long time. Here's his ties to the community. That takes time. I mean, that can take hours to potentially present a case. With 6 magistrates and 20,000 cases filed a year, we don't have that time.
I think
and functionally, you're not going to be able to do it. A court-appointed lawyer at the PD's office, if somebody gets arrested at 2 and they want to have a bond hearing at 4 in the morning, you ain't going to call witnesses. You ain't going to get documents there.
There's more felony courts than misdemeanor courts. I think I'm correct on that.
Yes.
Yeah.
How about more misdemeanor courts or more administrative judges or more ancillary where you can refer that motion to suppress out over there, a dispositive motion to suppress over here, have a trial over here? I think Harris County is severely underserved by the number of judiciary benches that are available. I mean, we're a massive county with just floods of individuals coming in on the system, and I do think that is a huge problem. And going back on what you said, Jason, I think, yes, you have to pay those individuals, if they're appointed, appropriately for the work that they do.
Some of it is going to have to require legislative change. Any judge is going to be reticent about getting a bonded person with the fear that person may do something to harm the community, then it's on you, right? Because you don't get in trouble for setting a high bond on someone. You get in trouble for setting a low bond on someone and that person doing something dangerous. There needs to be a change to the way we think about bonds with respect to especially nonviolent offenses, where the push is toward release rather than incarceration, and put the burden on the state, and this is a legislative change, but put the burden on the state to prove that a bond is required versus being the presumption being a release on a nonviolent offense. But the way this statute reads is the balancing act, and of course, No judge is going to say, well, you know, I don't want this. The same way that fortuitously a person without a driver's license may go out and, like, you know, hit his wife, and like there's some sort of connection between those two things occurring, but that person, that judge, gets in trouble for the slack.
Yeah, it's messed up. We're going to open up the phone lines. 713-807-1794 is the number if you want to call in with your questions for Raul and Jason. Also got Twitter up at HCCLA_TV. But let's hit our first phone call right now. Hello. Thanks for calling Reasonable Doubt. Hello. Hello.
Todd DuPont, how's everybody?
What's up, Todd?
Yeah.
I was about to start Buellering you in here in a second because you weren't catching on.
All good. Great show. I'll be quick. Both candidates, thank y'all for coming on. My question would be for each of you, thoughts and ideas for what you would change for what you see today. I'm going to hang up and watch.
Thanks, Todd. Appreciate the call.
Proud of all of y'all. Bye.
Thanks, man.
Those are unsolicited compliments. I've never met Mr. DuPont in my life. He just read our bios and figured out we're this good candidates.
Gave him a text message before he called in.
So go, Raul, what do you say?
In misdemeanor court, like I had mentioned earlier, most of the individuals, or a lot of the individuals that get arrested for misdemeanor cases are working class people. People that are living paycheck to paycheck. That's a lot of the individuals that I represent. And one of the things that I would like to see is those individuals not having to come to court if just because we have to reset their case for one reason or another. There's a lot of times that the state's not ready, they don't have the offense report, or they're missing the 911 tape or something, so we have to reset the case. So if you reset the case, then why not allow that defendant not to show up? We excuse his presence, because a lot of times the next setting, it's for the lawyer. It's for the defense lawyer to gather his evidence, to gather the evidence that they have against him, and then start formulating a defense. So you really don't need the defendant there. So one of the things that I like to see is having that person excused from having to come to court if it's a reset of that type. Now, of course, he has to come if there's motions, you know, trials and things like that. But that's one of the things that I would definitely like to see, and that's one of the things that I would do.
I agree with what Raul said, because we've all had clients who you're like, well, what does your work schedule look like? What day of the week is best for you, right? But also, I think the other thing is that one way a judge can help justice move along is those 4 magic letters, you know, WOAR, without agreed direct to the judge. And I've had lots of cases where we're at loggerheads, and nothing serious in terms of crime-wise, but the DA wants their pound of flesh, the defense lawyer thinks something differently, and I think as a judge, you know, you bring the perspective of having been a prosecutor and a defense lawyer, and I get, look, this case is not worth 2 years in TDC. Let's let them do, you know, 1244A. So I think that's the big thing that, along with that, is to help move cases along where we're not keeping people in jail or trying to punish people simply because we're mad at them without the real life experience of having represented both sides. I mean, I respect prosecutors, but until you've been you rarely see a defense lawyer become a prosecutor, but you see a lot of prosecutors become defense lawyers, and I know this probably happened for all of us. Our perspective just changes. You know, you have a better view of what a case really is worth, what the appropriate punishment is a case is when you've been a defense lawyer and you've represented people. And I think that's what we all hope to bring, that broader perspective to making sure that justice is done not only for the victim, but for the defendant, society, our citizenship, all those things.
Speaking of what's called without an agreed recommendation, it's when defense says one thing, prosecutor says one thing, and you can't agree to something, and we say, well, we'll just go to the judge and see what he says. That's tough. What makes you think that you can come up with a punishment for a case? Why do you, I mean, number one, that's hard. I don't think I can do it. Number one, how do you think that you're able to do it? And two, why do you think you're able to do it?
For me, my experience, practicing for 26 years as a criminal defense lawyer, handling 11,000 cases in that time, being a judge at the city of Houston for the past 12 years, all of that put together has given me the opportunity and the experience to be able to make those types of decisions. And one of the things that I would like to see in a misdemeanor court is having that individual not be incarcerated, because one, it costs money, and a lot of the times it's more of a rehabilitation. Most of the misdemeanor cases that are filed are DWIs. I think the majority are DWIs. So those individuals that are charged with DWIs, we have plenty of programs in Harris County that can resolve those DWIs without incarceration. Then we have individuals with mental health problems. We have a mental health, court. We have mental health facilities in Harris County that I believe are being underutilized. We have Veterans Court too for those individuals that are veterans. So we have those right now that can be utilized, and a judge can say, this is what I think, and he uses his experience to make those decisions.
From a felony bench perspective, you're going to have people 25 to life, murders, capital murders, life without paroles, no probation cases, 2 to 20s, 2 to 10. You think you can do that, and why?
Can you write that list out? Because I need to know what I'm in
That's
for.
tough,
He needs
man.
to take it home to his
I
wife.
got to take that, make sure I know that list of ranges of punishment. No, I agree. I think every judge tells you the hardest part is the idea of sentencing. But I've been lucky that both as a prosecutor, as a defense lawyer, I've learned from really good lawyers. I remember one of the great lawyers at the DA's office, Lillian McClellan, used to say, every good court can only be in trial maybe, 30 times a year, right? And you've got thousands of case pendings. Make sure each of those trials count. Not simply because you're mad at the defense lawyer because they wouldn't take a plea, or you're mad at the defendant, but because those cases need to be tried because they're serious. Same thing with dealing with these cases. There are cases that become 25 to life because the guy, two times his life had cocaine, or stolen, or felon in possession of a weapon,
Right.
easily becomes 25 to life at some point. So I think you have to apply that perspective to all those types of cases. And they're serious cases. Violent cases are the ones we should all be most concerned about. Things that indicate recidivism. So those things it's just a matter of being experienced.
Right.
And so that's the only thing, and I think Raul's correct, that your experience is, like the French said, that je ne sais quoi. It is that perspective of knowing. I mean, I grew up.
Stop cussing at me.
Sorry, I know my
Hey, what'd you
French,
call me?
as the French say. But I mean, having grown up in Southwest Houston, I mean, my school had 25% of every population. You just have a different perspective when you grew up in the environment where your clients come from.
Yeah.
That's the big thing about like Jerry Spence School of Trial. Live with your client, know what they do, and same thing. You'll know who your victims are. You'll know what it really means for them, what type of punishment they really want to see.
So you grew up in Houston?
I did. I grew up in Alief.
And where? A-Leaf.
Did you grow up in Alief?
No, I grew up in the Rio Grande Valley, South Texas, man. In Valle por vida.
Thought we were gonna have a reunion there. For
Yeah.
then.
What about you, Raul? Where'd you grow up?
I grew up in the north side, and I was born in Mexico. I'm an immigrant. My parents came here when I was 2 years old, and when they came to the United States, the first house we lived in was just right down the road from here in 2nd Ward. And so we lived in 2nd Ward before my dad bought a house in the north side. So I grew up in the north side, went to Reagan High School, graduated from Reagan, went to University of Houston, then went to South Texas College of Law. So I also lived right there in the barrio. And I lived with, in a house, a 2-bedroom house with 5 of my brothers. There's six of us, 6 kids, and my parents in a 2-bedroom, 1-bath house.
3 bunk beds.
And yeah, exactly. So I agree with Jason. I know how it is. We've been there. We've all been there. And these individuals that come before a court, those are individuals that I could see. I've been there in terms of the lifestyle that they live, where they come from, working class people. My dad was a working class man. So we can relate to those things.
I want you to relate to the next person that's on the phone here because we have another caller coming in. You guys are popular tonight. 2 calls. Hello, thanks for calling Reasonable Doubt.
I'd like to relate this question to Mr. Rodriguez.
Yes, sir.
Where does he stand in regards to a person being accused of sexual assault and being arrested for sexual assault and then find out he's an illegal and then he's sentenced to prison for 3 years and then he's deported, but now he's back?
Well, in my particular, the court that I'm running for, we don't deal with sexual assaults. This is a misdemeanor court that I'm running for. So I can't really answer the question that you ask. So that's more of a felony type of case.
So, Jason, we have a big population of undocumented people. How are you going to deal with that in the felony court? And I'll pose the question to you, Raul, too. We're in a situation where immigration's picking up individuals at the probation office. So those individuals, if they happen to bond out and get out before ICE puts a hold on them, they're faced with a situation with probation's not going to be an option for them, nor is going to jail, because they're going to get an ICE hold and get deported. So they're left with fighting their case. How you deal, and going to trial regardless, I don't know, but how do you anticipate dealing with a group, both prospective candidates, of people who are undocumented, or do you deal with them any differently?
I don't think you deal with them any differently with respect to what you consider for punishment. And that's how we can't handle whether ICE, we don't control whether ICE picks them up from the jail. So there's not much we can do on the state side to deal with the federal government. But a person shouldn't be treated differently or punished worse simply because they're undocumented. It's not cost effective. It doesn't increase deterrence. You know, people are going to come here regardless. I think we actually may be 2 original dreamers, right? 'Cause I came here when I was 4 months old from Vietnam as a political refugee. But I think that's the only thing we can do at the state level. And there are things that are going to have to be worked out with respect to legislation. You know, there's whether or not a person who is can be put on probation or deferred if they're undocumented. You know, the law is still kind of unsettled. You know, if I put someone on and then ICE comes and picks them up, I've represented people where they were deported after they've entered into deferred. Right. And then you got to resolve their case, and they're still open. It's a lot of strange things happen.
Well, you know, as a judge, the main thing that a judge has to do is follow the law. We want judges to follow the law. That's one of the things that we as criminal defense lawyers, we always aspire a judge to do, is follow the law. And immigration is a federal law. And me as a county criminal court judge and Jason as a state district court judge, we have nothing to do with immigration. That's out of our hands. So we can't rule on whether or not that person should be deported or detained or anything like that. That's out of our hands. That's not our role as judges in these courts. That's more of a federal role. So we have to treat that individual like we would treat any individual that comes before the court equally.
Let's talk about what a judge can do. Okay, we have this issue with pretrial interventions and pretrial diversions. What's the role, or what should be a role of a judge in a pretrial diversion that's being offered by the district attorney? Does the judge play a role in it? Should it play a role in it? And how, when, and why?
Well, right now in misdemeanor courts, pretrial diversions, pretrial interventions are recommended by the state. It comes from the state. You make a contract between the state and the individual and the defense lawyer, and really the judge has nothing to do with it. He just basically come before you and say, okay, you got pretrial intervention. I think that the judge should be a little bit more involved, because what if an individual may qualify for a pretrial diversion or intervention, but it's not offered by the state? What do you do then? You can go without an agreed rec, like Jason said, And why shouldn't a judge have a power to put somebody on a pretrial diversion or intervention? I think that judge should have that power. Yes.
What says you, Jason? What's the role of him?
That may be that I was going to say. I think that creates a legislative. You'd have to have a legislative solution for that. I think that one, I've always been in favor of pretrial intervention, even as a prosecutor. You know, if you had a clear criminal record and it was a minor offense, I mean, give somebody a chance. You know, it was a nonviolent offense. But really, the judge's role in pretrial intervention is to really get out of the way, and let the DA, if they feel it's appropriate, to do it. I mean, there may be some limited circumstance in which it shouldn't be appropriate, and we've kind of seen stories about that, like, hey, how did this guy get a pretrial intervention? Yeah. But again, that's
like the time Busby got one from.
I'm just saying, generally speaking. I'm saying, generally speaking.
Terminated like 6 months out. Right, like that.
Well, but and I know our current DA would like to get away from the current structure of how pretrial intervention is done, and obviously making changes tough. But I mean, the reality is it shouldn't even involve the court system at all. Period. End of story. I mean, there shouldn't. A pretrial intervention is that it's supposed to. It's a diversion. It's supposed to divert around the court system, and you're not supposed to have the courts involved or anything like that. And it just seems like they, for whatever reason, whoever decided to start this idea of having the probation department supervise them and do long resets, you know, reset the case for a year. That idea has just somehow took hold, and now here we are, and it's just not a good. It's not a good system. And so really, I feel it's like it's on the DA's office to change this thing.
I agree. I mean, they should do it like everyone else on the planet and dismiss on the front end, and then refile later if they need to.
But it's slow. I mean, it's gotta work itself out.
Which jurisdictions do it that way?
Almost every single other one.
No, Montgomery County doesn't do it that way. Fort Bend doesn't offer pretrial.
Well, they don't even. Well, right, they don't even offer.
Yeah, I mean, the ones that do offer it. I mean, McLennan County does it. Travis County does it. Bexar County, I think, does it that way.
I'm a judge of the city of Houston. Mm-hmm. In the city of Houston municipal courts, they do that. They will dismiss a ticket, and then later on, if they wanted to, they can just refile it.
Yeah.
It happens all the time in court, in municipal court.
I've done that before as a prosecutor. You know, as a kind of dismissal, if you do something wrong, we'll refile it. But yeah, and I wish you're right. I wish you'd like to see that more often, because there are too many cases.
Well, what I heard is that prosecutors have no more discretion on anything anymore, and they're getting micromanaged.
Have you read that?
That's what I heard. That's what I heard through a blog or something. I don't know. That's what I heard.
You're full of gossip, aren't you?
Well, okay, so let's talk about busting pleas. What's the role in a judge in accepting or rejecting a plea deal? A lot of times it's like, look, judge, I worked something out with the DAs. Butt out. This is our agreement. I mean, what's the judge's role, and what's the temperament that a judge should approach those situations?
Unless there's fraud. I mean, there are situations we've heard stories of collusion, not Russian collusion, but collusion.
There you go, using big words again.
I know. Well, I've been studying for the SAT again.
He did go to Rise.
But
C-O-L-L. Okay.
Sometimes you're there to save somebody from themselves too, right? Either, I mean, you'll see bad lawyers like, do you really want your client to take this deal where he's a lifetime registration or something else? Sure. Or the prosecutor, like, you know, you don't realize how good of a deal you've given this person, or whatever it is, or you're going too harsh. But for the most part, within the range of reasonableness, they should be able to do what they want, unless there's some level of, you know, if somebody's getting a probation on, like, you know, some serious offense, that their 10th offense, there may be problems.
Right.
I agree with Jason. In misdemeanor court, I think the judge should basically just, leave it up to the lawyers. I mean, they're the ones that are discussing the cases amongst themselves. Why should a judge come over and in a minute or two, you know, bust a plea? There are some judges, though, that will do that. There's one particular judge right now that I know of that won't accept anything less than a certain amount of time for a trespass.
Right.
Period.
Right.
And so if you have a deal with the DA for a trespass in this particular court for, like, say, 2 days, she won't accept it. Mm-mm. And, you know, they should just let them work out the case, and if they work out the case and come before me, I'm not gonna mess with it.
Who cares about it? I mean, why would you want someone to spend really an amount of time for unless there's a serious potential burglary of a habitation, sure. But
because they get points after a certain amount of days. If they get points, anything under 15, 20 days, they don't get a point. When they get rearrested, it's not counted against them for setting their bond. Yeah.
No, you don't realize. I mean, a lot of it is. Anyone watch The Wire?
Yeah.
Remember the show The Wire?
I know what it is. I've never watched it.
You're always juking the stats.
That's The Wire.
You're always playing with the numbers to make certain things happen, right? And you know,
in just this case, we're just doing it with people's lives. That's all.
I know I find that very problematic if that's the notion that you're trying to build a point system in the same way that, you know, in order to create to keep them in longer next time they're in custody on some minor offense.
Just score a higher risk.
Yeah, that's unfortunate.
So, how are you gonna do your docket, Jason? You're talking scheduling orders. You're talking super dockets. What you think?
Oh no, the super dockets. You know, actually, part of it you got to learn. I got to figure out how. One of the things you have to learn once you do them, but I am for what Raul said. I think most Democratic judges are for this: is getting rid of people for non-issue settings, non-dispo settings. Your client doesn't need to be there, but the lawyers need to be there. But I don't think the rocket docket. I've had so many judges who've like. It's your third court setting. Why aren't you set for trial? Because it's still my third court setting. That's why I'm not set for trial.
Just waiting on the rip call, Judge.
You know,
I mean, come on.
So, you know, part of it, you know, you can't create a rigid system. It's got to be flexible at a certain level. But I don't anticipate. I don't do any courts still. Are there only 2 courts that do rocket dockets? Judge Hart. And Judge Brown.
I think so. Yeah, that's right.
And I don't know if they've done the analysis to see which one actually works better or not. But I think that if we just had a waiver of appearance for non-dispo settings, that would go a long way to resolve it.
How are you going to run your docket, Raul?
Hey, as far as running a docket in misdemeanor court, it's not that difficult. I'm going to let the lawyers decide how long they need to handle their case. I'm not going to do a rocket docket or anything like that. If they say, well, I need a reset for this reason, but it's not necessary for a plea or anything like that, fine. The defendant didn't have to be there. I need a month-long reset because of I have to gather evidence, right? Okay. You know, I want you lawyers, between the defense lawyer and the prosecutor, you guys figure it out. How much time do y'all need? That's fine. I don't want to be a judge like some of these judges say, oh, your case is 90 days old and you need to do something now. You can't have that rigid, like Jason said, you can't be that rigid. You got to be flexible. Let the attorneys handle their cases, especially the ones that have been practicing. They know how long it will take. They know how long they need to handle their case. So I will let them take care of it. And if they need a reset, that's fine.
Are y'all thinking about being, trial courts? Like, oh, if we know it's Judge Rodriguez or Judge Long, we're going to trial in that court? Or are you guys, are you guys ready for that?
I just want people to say that, oh, you landed in a good court.
Oh, that's
what I mean?
Yeah.
If you don't go to trial, it's not because you're a bad court. It just means that things are working well. So I think that's the biggest compliment I would ever get is that, hey, your case landed in a good court.
Do you guys view this as, a lot of the judges we have now have been there for a long time. And I want to get y'all's perspective coming into this. Do you view it as something that, as a last stop in your career, or is it something that you want to do for a little while and then move on? And on top of that, should we explore possibly term limits for judges? How about it?
Good question. There's no term limits in associate judge with the city of Houston. Mm-hmm. Although you do have, it's on an appointed basis, so you have to be appointed every 2 years. In terms of the length of time, you get reelected or have elections every 4 years. So I'm kind of like Jason. I would like to be the judge that, oh, you landed a good court. And if the judges are to be elected in the future, which is probably what's going to happen, and if you're not doing a good job, then I'd say that the voters can say, well, he's not doing a good job, let's find somebody else. And in terms of what you had mentioned as far as a career, this is like my next level. I started off as a defense lawyer practicing criminal law. I became an associate judge at the City of Houston, and this is kind of like my next step. And my next step of public service.
Right.
I'm a public servant, and so I want to continue that, and maybe continue now in county court level.
I don't think you can have, I wouldn't be in favor of term limits. Though democracy and voting is not always the best way to pick judges, it's still the best process we have at this point. I do think judges have to be responsive to opinions if you're doing a good job. I know the Bar Association puts out a opinion of judicial poll opinions. I think it's important for judges to be mindful. If everyone hates you and thinks you're doing a terrible job, you need to do a better job. But I just think that this is something that our community, for running for judge, I think it's something that our community needs. I'm happy to do it for as long as people want me to do it.
We only got about a minute left. I didn't realize the time was going by so fast.
Can we talk about anything legal or other than?
I mean, we tried.
This is great. No, I mean,
tried, and then you started talking.
flies.
We
got about a minute.
French
well,
things and everything.
We got about a minute. 30 seconds. Raul, you got the camera, and then Jason.
I just want everybody to know I'm a candidate for Harris County Criminal Court at Law number 13. I'm the most qualified candidate for this particular bench. 26 years practicing criminal law, 12 years judicial experience. I'd like the citizens to vote for me.
30 seconds, Jason.
My name is Jason Luong. I'm running for the 185th, and this is an important year. This is your year as a voter to choose really qualified candidates. Every vote's going to matter, and I want you to go out there and vote in the March 6th primary or in the early voting for a good candidate.
Wow. I mean, that's all the time we got. That's it.
I didn't even get
When are you guys going to run?
Huh? I'm not going to run.
No.
Are you kidding me? I'm running for the door. I'm not going to run for office. Are you kidding me?
Oh, man.
If somebody came to me and proposed that, I'd be like, you're crazy. It's not going to happen.
Ardoan.
Yeah, no, that's not going to happen.
All rise.
No, not going to happen at all. But that's all the time we have for this episode, ladies and gentlemen. We will see you. I won't see you next week because I'm not going to be here. But are you going to be here?
I think Justin is taking the entire show on, our producer.
I'm not going to be here. I'll be back in 2 weeks, but we'll see who's keeping the show. Oh, well, we might have Victoria.
Vic's on the lead.
All right, well, I'll see you when I get back in 2 weeks. That's all the time we have for Raul Rodriguez, Jason Luong, and my co-host Julio Vela. Good night, everybody.